ಆಯ್ತಲ್ಲ ಈಗ ಬಂದಿರಲ್ಲ ಅದ್ಯಾ ಕ್ಯಾಮ್ರಾ ಲೈವ್ ಆಗ್ತಾ ಇದೆಯಾ ಬಂದಿಲ್ವಾ ಇಲ್ಲ ಬರ್ತಾ ಇಲ್ಲ ಬಫರ್ ಆಗ್ತದೆ ಮತ್ತು ಕ್ಯಾಮ್ರಾ ಏನಕ್ಕೆ ಬರ್ತಾರೆ ಆಡಿಯೋ ಎಲ್ಲಿಂದ ಆಡಿಯೋ ಅದು ಮೈಕಿಂದ ರಿಸೀವ್ ಆಗ್ತದೆ ಅದರಲ್ಲಿ ಮೈಕ್ ಇದೆಯಲ್ಲ ಆ ಮೈಕ ಈ ಮೈಕ ನೋಡ್ಕೋಬೇಕು ಸರ್ ಇಲ್ಲದೇ ಮೈಕ್ ಬರುತ್ತಲ್ಲ ಇನ್ಪುಟ್ ಅದು ಔಟ್ಪುಟ್ ಇದರಲ್ಲೇ ರಿಸೀವ್ ಆಗ್ತದೆ ಲ್ಯಾಪ್ಟಾಪ್ದಲ್ವಾ ಲ್ಯಾಪ್ಟಾಪ್ ಅಂತ ಯಾಕಂದರೆ ಅವ್ರು ಮಾತಾಡ್ತಿರೋದು ಇಲ್ಲೇ ಅಲ್ವಾ ಇದೇ ವಾಯ್ಸ್ ಇನ್ಪುಟ್ ಆಡಿಯೋ ಮಾತ್ರ ನೋಡಿಲ್ಲ ಇನ್ಪುಟ್ಟಾ ಹಾಂ ಯೂಸ್ ಅದಾ ಮೈಕ್ರೋಫೋನ್ ಸಿಗ್ನಲ್ ರಿಸೀವ್ ಆಗ್ತೀರ ಕಟ್ ಆಗಬೇಕು ಅದನ್ನು ಕರೆಕ್ಟಾಗಿ ಕ್ಲಾರಿಟಿ ಮೈಕ್ರೋಫೋನ್
ಇದೇನಾ OBS ಸ್ಟುಡಿಯೋ?
ಹೌದು. ಕರೆಂಟ್ಲಿ ನ್ಯೂಸ್
ಈಗ ನೋಡಿ ಸರ್ ಗೊತ್ತಾಯ್ತು.
ಇಲ್ಲ ಅಲ್ಲಿ ಏನ ಇದು ಸೆಟ್ ಮಾಡ್ಕೋಬೇಕು OBS ಅಲ್ಲಿ.
ಬರ್ತಾ ಇದೆ ನೋಡಿ ಸರ್, ಔಟ್ಪುಟ್ ನೋಡಿ ಸರ್.
ಇಲ್ಲಿ ಮೈಕ್ ಇದು ಬರಬೇಕಲ್ವಾ ಬೇರೆದು? ವಿಡಿಯೋ ಆಡಿಯೋ ಇನ್ಪುಟ್ ಇದೆ ಅಲ್ವಾ?
ಇಲ್ಲೇ ಕೇಳಿಸ್ತಾ ಇರೋದು, ಇಲ್ಲೇ ಕೇಳಿಸ್ತಿರೋದು. ಇಲ್ಲಿ ಮಾತಾಡ್ತಿರೋದು ಕೇಳಿಸ್ತಿರೋದು.
ಓಕೆ. ಲ್ಯಾಪ್ಟಾಪ್ ಇದೆ, ಲ್ಯಾಪ್ಟಾಪ್ ಇದಕ್ಕೆ ಬೇಗ ಬರಬೇಕಲ್ಲ. ಇದು ಗೊತ್ತಾಗುತ್ತೆ
ಅಲ್ಲ, ಇದು ನೀವು ಅಂದಮೇಲೆ ಏನೋ ಹೋಗುತ್ತಾ ನೋಡಿ,
ಹೋಗಲ್ಲ
ಏನೋ ಡಿರೆಕ್ಟ್ ಆಗಿಲ್ಲ.
ಇದೆ ಇಲ್ಲೇ ಡೇಟ್ ಆಗಿಲ್ಲ
ಸರ್ ಇದು ಕರೆಂಟ್ ಆಗಿದೆ. ಹೇಗೆ ಬರ್ತಾ ಇದೆ ಆಡಿಯೋ? ಸಾಂಗ್ ಆಗ್ತಿರೋದು ಮೊಬೈಲಲ್ಲಿ ಬರ್ತಾ ಇದೆಯಾ? ಅದೇ ನಮಗೂ ಡೌಟ್ ಹೊಡಿತಾ ಇರೋದೇನು ಅಂತ.
ಇದೆಯಾ ಅದರಲ್ಲಿ ಏನಾದ್ರು ಹೆಡ್ಫೋನ್ಸ್ ಇದೆಯಾ? ಹೆಡ್ಫೋನ್ಸ್ ಇದ್ರೆ ಅದಕ್ಕೆ ಹಾಕ್ಬಿಟ್ಟು ಅದರಿಂದಲೇ ಹೋಗ್ತದೆ. ಅದಕ್ಕೆ ಈ ಪಿನ್ ಏನಾದ್ರು ಹಾಕ್ಬೋದು ಅದಕ್ಕೆ.
ಟೀಮ್ಸ್ ಏನಕ್ಕೆ
ವೈಬ್ರೇಟ್ ಆಗ್ತಾವಲ್ಲ ಅದನ್ನು ರೆಕಾರ್ಡ್ ಅದಕ್ಕೆ. ವಾಯ್ಸ್ ಎಸ್
ಯಾವುದು
ಅದೇ ಇದು ಎರಡು ಬರ್ತಾ ಟೀಮ್ಸ್ ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ. ಟೀಮ್ಸ್ ಮಾಡಿ ಟಿವಿ ಬರಲ್ಲ, ಟೀಮ್ಸ್
ಇದು ಅವ್ರಿಗೆ ಅಷ್ಟು ಬಂದು ಸಾಕಲ್ವಾ? ಈಗ ಪ್ಲೇ ಆಗುತ್ತಲ್ವಾ ಅಲ್ಲಿ ಅಂದರೆ
ನಾಯ್ಸ್ ಬರ್ತಾ ಇದೆಯಲ್ಲ,
ನಾಯ್ಸ್ ಬರ್ತಾ ಇದೆ.
ಅದೇ ಸರ್ ಯಾವ್ದು ಸರ್ ಏನು ಹೇಳ್ತಾರೆ? ಏನೋ ನಮ್ಮ ಹತ್ರ ಇರೋದಿಲ್ಲ, ಇವಾಗ ಚಾರ್ಜ್ ಒಂದು ಗಂಟೆ ಕೊಡ್ಬೋದು.
ಚಾರ್ಟ್ 150ನಾ?
ಹಾಂ
11 ಓಕೆನಾ?
ಬೇರೆ ಆಪ್ಷನ್
ಹೌದು.
ಅದನ್ನ ಲಿಂಕ್ ಕಳಿಸಿ
ಯಾರಿಗೆ?
ವಿನಾಯಕ್ ಕಳಿಸ್ತೀನಿ. ಈಗ ಒಂಥರ ವಿನಾಯಕ್ ಅದು ಶರ್ಟ್ ವಿನಾಯಕ್. ಓಕೆ
ಓಕೆ ಬ್ರೋ ಯು ವಿಲ್ ಶೇರ್ ದ ಲಿಂಕ್ ಟು ಹಾಯ್. ಓಕೆ
ವೇಣ ಮೇಲ್ಗಡೆ ಹೋಗ್ಬೇಕು ಇವರು
ಹೋಗೋಣ.
ಸ್ಟಾರ್ಟ್ ಆಯ್ತಾ? ಹೋಗಲ್ಲ ನೀವು ಮಾಡಿ, ನಾನು ಲಿಂಕ್ ಕಳಿಸ್ತೀನಿ. ನಮಗೆ ಟೀಮ್ಸಲ್ಲಿ ಮಾತ್ರ ಆಯ್ತಾ?
ಟೀಮ್ಸ್
ಏನು ಮಾಡಿ ಏನು ಮಾಡ್ಬೋದ? ಹಿಂಗೆ ಟೀಮ್ಸಲ್ಲಿ ನಾವು ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ, ಆಲ್ರೆಡಿ ಬರುತ್ತಾ ನೋಡಬೇಕಷ್ಟೇ. ಇದೆ ಮೈಕ್ರೋಫೋನ್ ನೋಡಿ
ಒಂದೇನೆ
ಇದು ಯಾವುದಿದೆ
ಅರೆ
ಯಾವುದಿದೆ ಇನ್ಬೋರ್ಡಾ
ಮುಂಬಿಡ
ಹಂಗಾರೆ ಇದು ಲೇಟ್ ಆಗಿಲ್ಲ ಅಣ್ಣ ಇಲ್ಲ ನಿಮಿಷ ಇದು ಡಿಲೇಟ್ ಹಾಕಿಲ್ಲ ಏನೂ ಮಾಡೋದಿಲ್ಲ ನಾವು ಇದೇ ನಮ್ಮ ಡಿಫಾಲ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಚಾನಲ್ ಡಿವೈಡ್ ಮಾಡ
Are we playing some music? ये टेस्टिंग आप कर रहे हो? So you are sorry? It's not started. Is it now? Can we check it in the other panels? Right. Yes, sir. You can check it. What do you SHI Shashika Saurabh KNTS
ಸರ್ ಇವಾಗ ಅವರು ಫಸ್ಟ್ ಸೀಟಲ್ಲಿ ಕೂತ್ರೆ ಹೇಳ್ತೀರಾ ಯಾಕಂದರೆ ಅವ್ರು ಚಿಪ್ಸ್ ಪಾಸ್ ಮಾಡಬೇಕು ಡಿಬೇಟ್ ಆಗುವಾಗ ಪಾಸ್ ಮಾಡೋಕ್ಕೆ ಸ್ವಲ್ಪ ಹಾರ್ಡ್ ಇರುತ್ತೆ.
ನವೀನ
between speaker 1 and speaker 2 for petitioner is 16 minutes and 14 minutes respectively. The time split between speaker 1 and speaker 2 of the respondent is 13 and 17 minutes respectively. With your permission, can you begin the proceedings?
So, you speak 30 minutes.
30 minutes.
And what would be what is
Yeah.
Yes. Yes. Greetings to the Honourable Bench. Honourable Bench, this is the Council appearing on behalf of the petitioners in the instant matter. I will be dealing with issue 1 in its entirety and issue 2 in parts. Honourable Bench, if I may have the permission to proceed.
Yeah.
Honourable Bench, under issue 1, I will be dealing with 3 things. How the preventive detentions, data privacy breaches and restrictions on public screenings have tantamounted to a violation of Article 21. Honourable Bench, if I may proceed.
Yes.
Honourable Bench, preventive detention is always seen as repugnant to democratic ideas. It has been seen as an anathema to the rule of law. The Amina Begum judgment, which has been cited numerous times,
sorry, not so much democratic idea, but the idea of personal liberty.
indeed, Honourable Bench, 100%. And Honourable Bench, it is due to that liberty that Amina Begum's judgment has cautioned against the normalization of something like this. Rekha versus State of Tamil Nadu said that yes, Article 22 gives you an exception, but an exception is just that, Honourable Bench, an exception. It cannot nullify the full force of the main rule, which is liberty. Honourable Bench, we struggled for years to get this one thing. That is liberty, and that has to hold the highest importance in our democracy. Honourable Bench, in the instant matter, if I may draw you to the moot proposition, it has clearly been stated that Abhinav Sharma and certain petitioners attempted to publicly screen a documentary. Now, Honourable Bench, there may have been a banning from certain portals like Netflix from screening it. There was no ban under the cinematograph against it. Therefore, the documentary wasn't illegal. Moreover, these particular screenings, attempted screenings, Honourable Bench, happened in Aryabhatta National University. There was no section 144 order imposed there. So, Honourable Bench, the initial public screening attempt that was curtailed on the grounds of law and order, Honourable Bench, this Honourable Court, and we have seen that law and order is not a ground to restrict freedom of speech and expression. It really is not. So, when they were curtailed from doing the public screening on the grounds of law and order, they didn't persist with it. They did not defy that order. However, they exercised their rights under 19(1)(b) to peacefully protest without arms. The Ramlila Maidan judgment has upheld that right. Honourable Bench, in circumstances like that, to curtail their rights of freedom of speech, to curtail their rights of liberty, and to use preventive detention against them is completely arbitrary. Honourable Bench, the primary reason why Section 3 of the National Security Act, which has been invoked here, has still been upheld is due to the procedural safeguards that it has, as it was seen in A.K. Roy's judgment. However, in the Honorable Bench, in the present case, the petitioners weren't even told which law they were being detained under, what the grounds of their detention was. That is the first primary safeguard that preventive detention calls for. If that is not complied with, Honorable Bench, how is this justified? Honorable Bench, Samavaruna judgment, Samavaruna versus State of Telangana, said that the only way you can invoke preventive detention is if you draw a proximate link between past conduct and the apprehension that in the future they will act in a way detrimental to national security or public order. But Honorable Bench, the petitioners here had no past criminal history, they weren't involved in the riots, they had done absolutely nothing unlawful. The one thing they tried to do, which was scream something publicly, they were denied and they did not go ahead with it. What kind of a reasonable...
Counsel, are you not defying the government order, right or wrong? Not to scream, there was an order.
Indeed not, Honorable Bench. It was not there in Aryabhatta. The 144 order was imposed state-wise, Honorable Bench. Aryabhatta did not have an order, and therefore the public screening couldn't have violated the law. Honorable Bench, I 100% agree that if a 144 order...
No, there was a general order.
There was a law and order advisory from the local police, Honorable Bench, and there is no moot proposition fact claiming that this was done with the authority of a magistrate. And Honorable Bench, we have seen countless times that under 19 clause 2, which are grounds to say curtail freedom of speech and expression, law and order isn't one of them. Honorable Bench, Romesh Thapar's judgment of Ram Manohar Lohia, it clearly stated that there are 3 concentric circles. The largest concentric circle is law and order. Within that, we have public order, and the smallest is security of the state. Honorable Bench, something that touches upon law and order need not touch upon public order. Honorable Bench, if I may draw your attention to 2 cases that are of paramount importance.
Sorry, your general proposition that normally the proximity between your present act and your past conduct, in which case if you stretch that proposition, then no one can for the first time be able to preventively detain.
Honorable Bench, but that is the point of preventive detention. Honorable Bench, that is to an extent the point of preventive detention. You don't just preventively detain anybody. It is something that's supposed to be used in very rare and exceptional cases.
That's right.
Indeed.
I'm not saying that preventive detention is to be an everyday affair. But to say that unless the past conduct is something which is not acceptable, only then that a person can be detained preventively may not stand scrutiny, because then no one can be detained.
Understood, Honorable Bench, but to use it against students who are doing it within their university campus for a campus debate on freedom of press, Honorable Bench, this was a law school. We are all taught from day one, express your opinion, express your dissent, you have the right to free speech. To curtail that when it's just students, a peaceful assembly, Honorable Bench, they didn't have Indeed.
No, but whole thing started because you wanted to scream.
Indeed,
That documentary or
Indeed.
But there was prohibitory order.
Not in that particular state, Honorable Bench, that we visit. In Aryabhatta, if I may draw your attention to the moot proposition itself, Honorable Bench, if you may see, paragraph 7.
1 minute.
Yes.
So when was that issued?
Honorable Bench, paragraph 7, that talks about the 144 order. It is on the 2nd page, Honorable Bench. It clearly states that the state governments in Vistara and Videsh issued prohibitory orders. Honorable Bench, the subsequent paragraph talks about how this particular screening attempted to occur in Aryabhatta National Law University. Honorable Bench, there were no 144 prohibitory orders in Aryabhatta. Therefore, their actions couldn't have been unlawful.
No, 144 action was when order was passed under 144. But in spite of that, you wanted to screen.
Honorable Bench, the moot proposition para 8 says
Para 7.
Indeed, but Honorable Bench, para 8 says they sought to screen it. They sought permission from the university. Can we go ahead with this? The university said no.
No, you should have challenged that 144 order that stage itself.
Honorable Bench,
You are not. Nobody has challenged it. So as long as that order is there, you can't do anything.
However, Honorable Bench, the state in which the screening was attempted did not have a prohibitory order. That is what we are trying to submit, Honorable Bench. The prohibitory orders were in Vistara and Videsh, not in Aryabhatta, Honorable Bench. It is almost
to say Aryabhatta National Law University is in a different state.
Aryabhatta National University is in Aryabhatta. Mistara and British are separate states. And therefore, when 144 isn't even there in Aryabhatta, Honorable Bench, how are they supposed to know that they are not supposed to do this? And when they were denied, they didn't go ahead with it. They engaged in a peaceful protest within the university campus. That is all our humble submission is.
Get that it's only that Aryabhatta is different
We
state.
don't get that
We don't
they are
get it doesn't
different
flow from
states.
this. I mean, you have said that, but it doesn't flow from this.
Honorable-
Aryabhatta is a separate state.
Indeed, but if I may just elaborate, because paragraph 7 explicitly mentions 2 states.
That's right.
However, if it had said that 144 was imposed in multiple states or various states, that is one thing. It clearly says Mistara and Vish for a specific reason. Because Aryabhatta was not one of those states subjected to the 144 imposition.
No, it's not clear from this whether Aryabhatta is a state at all or just the name of a university.
Indeed, honorable point taken. Even if there was a 144 on honorable bench, if they had screened that documentary, then if they were preventively detained, we would still understand.
No, what is the object of 144?
Honorable bench, it is to curtail breaches of
Gathering
right.
of people,
Indeed,
isn't it?
indeed,
So by screening, you are not going to look into yourself.
indeed,
The entire student body will be there.
indeed.
So
Honorable
it will be a group of students. So you are behind 144. That's what we are saying.
Indeed, however, honorable bench, the 144 order was given for a specific reason to curtail public screenings, not to prevent a peaceful gathering within a university campus. That is the point we are very humbly trying to make, honorable bench. That right should not have been curtailed. It is a fundamental right under 19(1)(b). Moreover, honorable bench, this preventive
What is
detention.
your differentiation between public and private screening?
Honorable bench, private screenings is generally with there is actually a
Private is inside the home.
Indeed, and honorable
Now
bench.
public, college one itself can be a public function.
Indeed,
And a university can be a public function.
yes.
It's a public place.
It is a public place.
Indeed, however, honorable bench, we don't just let anybody come into the university. My university doesn't allow us to walk in without an ID card.
Nobody need come out from outside.
However, on
Inside only it can be a law and order problem.
it could be a law and order problem, honorable bench, but law and order is not a ground to curtail freedom of speech and expression.
No, for 140,
144, we are on
not 1940.
Indeed, however, honorable bench, was preventive detention the measure they should have taken? Preventive detention curtails their rights completely. You are not given recourse to what you are given when you are arrested. And that to students, honorable bench. From day one, we are taught express your opinion. And when we express our opinion, they preventively detain us under a law that has been challenged to be draconian for years on end. And honorable bench, that is not where it ended.
Please develop that.
Indeed. Otherwise, this preventive detention then led to data privacy breaches. There are 2 major fronts to this. The people who were preventively detained, their phones were seized, and then their personal messages and data was accessed. On which there isn't a single provision in the National Security Act that they use here to allow either for a seizure or a breach of data privacy. Why was that done, on the bench? Even the Bharatiya Nagrik Suraksha Samhita, it does not allow for such. It allows for warrantless seizures if there is the suspicion of commission of a cognizable offence. Peaceful protesting isn't a cognizable offence, on the bench, and we're very humbly submitting that in PUCL versus Union of India, which is heavily cited everywhere, the court said one thing, and I quote, that security of privacy against arbitrary intrusion by the state is always frowned upon, and it does not need historical commentary to prove that it is against human rights. PUCL versus Union of India, People's Union for Civil Liberties, on that. Otherwise, Anuradha Basin's judgment, landmark judgment, said that when the state is collecting data, there are 3 things the state needs to do. It needs to get consent from the individual, which was not given as per the Moot proposition. There has to be safeguards in place, and it has to be on the authority of some sort of a law, not on the authority of the police, honorable bench. We understand that the role the police play in our democracy, but they do not have sweeping powers as such.
You cannot say there is no statute for it.
Indeed not, honorable bench. And one more point, honorable bench, there has been a restriction on public screenings. Honorable bench, the right to liberty isn't just that. It includes the right to access information. We have the right to disseminate information. How is that being curtailed? They are stating that pre-election period, we cannot allow this to happen. But it is in that pre-election period.
Okay. What is liberty?
Honorable bench, liberty defined in the UBHR talks about our ability to be without arbitrary restraint, our ability to move freely without arbitrary constraint by the state or anybody else.
No. liberty on the part of an individual.
Honorable,
Liberty on the part of a citizen. How to measure it?
when your ability to do something is restrained arbitrarily, that is what we talk about liberty. However, Honorable Bench, Article 21 in the judiciary, it has been developed. The scope of it has evolved to grow into having within its ambit the right to know, the right
Is
to
it absolute? Absolute?
Absolutely not. Article 21 is not absolute.
Then-
However, Honorable Bench, the restrictions that are put on it have to be reasonable. There has to be procedure established by law.
Reasonable, huh? Who will judge the reasonable?
Honorable Chintaman Rao versus State of Madhya Pradesh talked about what reasonable restriction is. It is something that is not arbitrary, something that is not excessive. Honorable Bench, here the restrictions put were excessive. A student within a university wants to hold a debate.
No, you have to keep in mind
Indeed.
the screening, that documentary started riots and everywhere as the proposition is
Indeed
mentioned.
not, Honorable Bench. If
No,
I-
it's mentioned.
Indeed not, Honorable Bench. If I may draw your attention to paragraph 4. Honorable Bench, the only reason that the protests happened, not riots.
Certain social media influencers also criticized this led to sporadic protests.
Indeed, Honorable Bench, it was not.
Notably, demonstration turned into violent,
Indeed.
resulting in property damage and communal tension.
And Honorable Bench, there are
Then-
multiple cases where similar issues have happened and the states have termed in law and order issue. Arun Ghosh versus State of West Bengal, Honorable Bench. A man had been assaulting, molesting women in an entire neighborhood for a period of 36 months. The court came in and said that this is a law and order issue because it doesn't affect the community at large. Sheikh Nazim's case, Honorable
But
Bench.
this affects is what the facts say.
However, Honorable Bench,
Affected, not affects, it has affected on.
It has affected already. In paragraph 4, last line.
Honorable Bench, just 2 points. One is that when you're imputing something to affect public order, you have to draw a live and proximate link, a direct link, not something that is intermediate. So if something happens in the middle, you cannot impute that to the main source. Here it is because social media, people on social media were using it, it was being, and Honorable Bench, the greatness of the violence has also been specified. It said property damage and communal tension. Honorable Bench, in a place like India, there is always communal tension. And property damage is not a public order issue, Honorable Bench, it is merely.
So we don't use, everything is under Article 21 free, do whatever you want.
Indeed not.
And we,
No, indeed not, Honorable Bench. If a reasonable restriction is required, then it should be imposed, but not in this case, Honorable Bench.
But it can be curtailed when there is clear and present danger.
100% clear and present danger to public order, to national security.
Is that is the duty of the state to take action?
100% Honorable Bench, but the 2002 Godhra riot, since it occurred, there have been 1300 documentaries and films on it. So why curtail the one film that is dissenting against the government? Honorable Bench, just because an opinion is
No, that's not
unpopular.
far-reaching. It has got far-reaching effects.
because the effect has already started.
Yes, started that.
Indeed, Honorable Bench. However, we have to understand that every judgment on freedom of speech and expression has said that critical appraisal is the cornerstone of democracy. Just because the ruling party isn't comfortable with the truth that is being imputed doesn't make it detrimental to our national integrity and our security. I 100.
You have never said that so far.
Yes. Honorable Bench, that is.
That's
Honorable Bench, that is my issue too.
We are driving you to that.
That is part of issue 2, Honorable Bench. If I may get into it.
Sorry.
Yeah.
That is part of my issue 2, which is why I was refraining. I apologize. Honorable Bench.
That was the.
Oh,
That's- that is the-
now getting into that. Honorable Bench, when it comes to issue 2, which we're looking at the non-justification under 19 clause 2, firstly, the burden is upon the state to prove that its restrictions are valid under 19 clause 2. They have invoked 5 grounds, Honorable Bench, 2 of which don't even exist in 19 clause 2. Potential to cause communal disharmony. Trade relations aren't recognized grounds under 19 clause 2. And when they bring up grounds like national security, we have to understand that Ramesh Thakur's judge in Ram Manohar Lohia has defined what a threat to national security is. We're looking at the endangerment of the foundations of the government, overthrow of the government, war, civil strike, revolution. Honorable Bench, that standard isn't met at all here. And Honorable Bench, even when we look at cases like FA Pictures International, Ramesh Pimple and Ramesh Delai, Honorable Bench,
No,
every single.
that place is
Yeah.
the minimum calling for international sanctions against women.
Indeed, Honorable
Does it
Bench.
not affect the sovereignty of the
Honorable Bench, but the same moot proposition also states, if I may just guide you to it, paragraph 12.
line 5, paragraph 4?
Honorable Bench, I duly acknowledge that, but if you draw your attention to paragraph 12, I will show you how there has been no international repercussions. Honorable Bench, it clearly states that foreign governments, the last line, foreign governments refrain from comment citing non-interference. Honorable Bench, this allegation that it's affecting our UNSCC, Honorable Bench, if you may turn, if I may just tell you, if you may turn your attention to page 82 and 83 of the document.
Paragraph 12 have got nothing to do with this.
Honorable, however, they are stating that the friendly relations with foreign states has been hampered. Here it's saying that foreign governments refuse to even comment on it, saying that we will not interfere, which means no diplomatic strain had been incurred. And Honorable, all this allegation about the UNSCC being jeopardized, Honorable, we have attached the Human Rights Watch's report on India's investigation. It is on page 82 and 83 of the petitioner's compendium. Honorable, that particular Human Rights Watch clearly stated that India has started using sedition laws, national security laws, the Information Technology Act to curtail students and activists and anybody who voices their critique against the government. Honorable, these are the things, and that report, the Amnesty International report of 2024, stated that this is why India's UNSC seat has been jeopardized. They are trying to use the documentary as a scapegoat to shift the blame. But Honorable, a particular documentary about our historical events, about our history, isn't going to incite any of this. Honorable Bench, the Rajagopal versus State of Tamil Nadu case, Ramesh Dalai, it was also a film, it was a documentary in fact, on the violence between Hindus and Muslims. Honorable Bench, the court said that it is when the moment or the hour of strife is over.
What about the state of Maharashtra versus Bhavra?
Oh, Honorable Bench,
Gavde case?
I am not aware of the case, I am exceedingly sorry. However,
Prevent in detention whether there was material suggesting a real and imminent threat. This is what it is. Imminent, suggested. So, what is wrong with that?
However, Honorable Bench, the courts, as they have said, that the 2002 riots are a huge part of our history. And it is up to filmmakers and it is up to us to decide how we talk. Honorable, this happened 23 years ago. How will an event from 23 years ago suddenly incite all of this? This has already happened. Now there is a document.
It happened then, but you are showing it now. And you know, more than the written word, the seen thing.
100%.
Visual impact is more.
But Honorable, don't the citizens of this country have the right to know what happened in our country?
They do have, there's no doubt about that. The question is balancing.
And Honorable, this is balanced. There are multiple other documentaries that are more inflammatory that the Cinematograph Acts Board has curtailed. But this is not, Honorable. It merely states that it talks about the political trajectory of the Prime Minister. Honorable, again, unpalatable opinions are not grounds to.
That's true as a proposition.
And Honorable, there are multiple other grounds have been cited. They have said that this is
No, when we
seditious.
say political, why to take it negatively?
Sorry.
Right? Political trajectory. Why you want to look into it negatively?
Honorable, because politics has both positives and negatives. Honorable, an election is coming up. The people have the right to make an informed choice about who governs them next. And so it is important that they know the full picture.
So, who has decided it?
Yes.
BBC.
Honorable, it is,
BBC prepared that documentary.
Honorable, but it got.
And no,
Yes.
we don't know what are the vested interests of BBC.
However, Honorable, one point I would like to add is India is UK's biggest partner in terms of trade. Moreover, Honorable, the only reason why the documentary
BBC is independent.
Honorable,
They can do whatever.
exactly, Honorable, they're independent, which means they were not influenced by anything else. BBC has always shown what is true. And Honorable, if I may just add one point, if the Indian board, if it was not approved under the Cinematograph Act, it would have never been aired. Which means there was caution that went into it, there was an approval, and then it was released into the public domain. Otherwise, there has been checks and balances taken. There is a reason why it was floated within the country. And Honorables, these are our fundamental rights. They cannot be curtailed arbitrarily. They have imputed sedition. Honorables, the word sedition isn't even in 19 clause 2. It was deleted from the draft article because it was stated in Kedarnath that inciting bad feelings against the government. The term sedition, Honorable, it says incitement to offence now. That is because when you're inciting bad feelings towards the government, it is not seditious. Only when you're causing it maliciously to overthrow the government, it is. And therefore, Honorable, none of
Even if it is affecting public peace and ending in violence, that affects it.
Our honorable, the only violence they have been able to show is property damage. To
That is
spare
violence again.
Our honorable, that is a law and order issue. Honorable, we can't curtail the entire country's parliamentary right because 2 chairs were broken in a university.
You are concentrating only on property damage. There is also one is
Communal
communal tension.
Honorable,
That's more dangerous.
100%.
That's more dangerous.
But honorable, it is just that, it's communal tension. Honorable, if we step out into the street right now, there will still be communal tension, whether there has been something or not, because that is something our history dictates, and it is unfortunate.
That doesn't mean that the action should be taken, should not be taken.
I'm just stepping on the street. Thank God there is no communal tension.
However,
I am
honorable,
safe enough to walk.
Honorable, there is a difference between communal tension and communal violence. That's the only. If there was communal violence, I understand why there would be a restriction. And
Communal
honorable,
tension is only half a step prior to
indeed,
communal violence.
indeed. Honorable, that is our humble.
Anytime it may explode.
And please see here,
And that is why-
demonstrations turned violent.
Yeah.
Yes.
It's not that violence
That's
is
right.
absent.
No, honorable, however, it demonstrates how that violence happened via the means of property damage and communal. I completely understand your point, honorable, but
It's
here.
not that simple.
100%. But here, our humble contention is that the 19th clause to grounds were met, making it against the freedom of speech and expression, freedom of press under 1918, and that would be all for us.
You don't want to touch upon proportionality?
We will, honorable bench, with
Yeah.
courage as well. Honorable bench, if I may take your leave.
May it please this honorable court, this is the co-counsel on behalf of the respondents. My co-counsel has already addressed the preventive detention question. I will be addressing specifically, I will be summarizing on the point of Article 19(1)(a) and the infringement of it, and then moving on to the final issue, which is the... Yes, sir. Yes, Your Lordship, I will be then moving on to the final issue, which was regarding Article 14 violation by the violation of procedural safeguards in the IT Act. Your Lordships, the documentary Belmore and the Pranav question is political speech at its purest. It is critiquing the state's action during the 2002 riots. Para 2 of the Moot proposition clearly states that it just includes interviews with riot survivors, with diplomats, and with political analysts. This would fall squarely within the scope of political speech. In Shreya Singhal versus Union of India, this court made a distinction between advocacy, criticism, and incitement. The court held that even when there is advocacy of violence, if it does not reach the scope of incitement, it would not violate Article 19. Your Lordships, the right to criticize Shreya Singhal versus Union of India, Your Lordship.
Yeah, Shreya Singhal.
Yes, Lordship. The more recent judgment, if I could bring to the court's attention, is Kunal Kamra versus Union of India, the Bombay High Court judgment, where the court struck down the fact-checking unit under the IT Rules 2024. The court held that the state cannot have a monopoly of truth and decide what is true and what is false. This would create a chilling effect where people would self-censor, and this would destroy the marketplace of ideas. The court held that the marketplace of ideas is not merely a forum of agreement, but a forum of disagreement. Yes.
No, this was not only the case of about facts, but also releasing confidential documents.
You use that beautiful expression, marketplace of
Market.
ideas.
Yes.
Can you tell us who used that first and where is that?
Your Lordship, I cited that from the Bombay High Court judgment where Justice Gautam Patel's
Not
judgment.
the
Authority.
Justice Gautam
it's
Patel.
a great Justice Holmes.
Justice Holmes, yes, I believe he gave the clear and present danger test
That's one
also.
of the greatest judges who ever
Yes.
sat anywhere in the country.
Yes, Your Lordship, on the point of confidential information, if I could direct your attention
I think
to...
that's the famous case of Abrahams.
Yes, Your Lordship, thank you. I will-
Please read it.
Yes, Your Lordship.
Lordship.
Yes, Your Lordship. Your Lordship, if I could direct your attention to para 2 of the Moot proposition, the final line, it merely states confidential documents purportedly leaked from governmental archives. So there is a question whether these are leaked documents or not, purportedly leaked from the governmental archives.
Source is not important, counsel. It is leaked.
Your Lordship, yeah, but the public
They are
also,
available on the documentary.
Your Lordship, the public also has a right to know, and there's a journalistic freedom that this court has read into Article 19 in Union of India versus Association of Democratic Reforms. The court held that when voters are voting, they are expressing themselves and that they have a right to know about the candidates. It is precisely for this reason that they should know about this documentary and about their history, because voters before an election, especially, they should understand what is the context in which they are voting.
That being the case,
It's not exactly in the context of elections.
Yes.
This is, vote is, election is coming.
Indeed.
This is not exactly, we don't even know who is the candidate, for which seat, and what are their credentials. That stage is not come.
Not yet come.
Just factors in.
Not yet come even otherwise. If a council wants to take that stand and the court has all reasonable right to take a stand that there is a motive. There is a motive to broadcast it to pollute the minds of the people, voters.
Even if your theory of election is accepted,
Accepted.
it is only
That is proved. Purpose is to pollute the minds and to influence the voters against the rule of Prime Minister.
Your Lordship,
If your argument is accepted, if that case ratio is accepted, obviously it is very clear that government is justified in taking this action.
No, but it may not be wrong to influence the voters against the Prime Minister.
No. Not against the very idea. See, to give the fact, to take their own decision, that is fine. It is other way around. To reject the person in such a way.
I think that is.
No.
Your Lordship,
Prime Minister on the passive next story.
Your Lordship, para 5 of the Moot proposition, one of the grounds listed is potential to incite communal disharmony, especially given the upcoming general election. So we do understand that general elections are coming. And furthermore, this is just interviews with riot survivors, this is interviews with political analysts and foreign diplomats. So this is informing the voters, regardless of what viewpoint it is presenting. The constitution protects the debate, and this is even if it is a viewpoint that is against the current government, that is protected speech under the constitution, Your Lordships. Your Lordships, therefore, it is most humbly submitted. I would seek to conclude this issue that the present blocking orders infringe Article 19(1)(a) and that they are not protected under Article 19 Clause 2 as my co-counsel has substantiated on Article 19 Clause 2. I would seek to move to the final issue. Yes, Your Lordships. Your Lordships, the final issue that it infringes, the blocking orders infringe Article 14 of the Constitution. This issue will be dealt in a threefold manner. Firstly, that it violates the procedural safeguards that are laid down under the IT rules, information technology rules, and secondly, that it does not meet the proportionality standard, and finally, it is not in compliance with the judicial stay on the IT rules 2021, Your Lordships. Firstly, Your Lordships, there are two rules that are questionable in this that are in issue in this case. The Information Technology Procedure and Safeguards for Blocking 2009 and the Information Technology Digital Media Ethics Code and Intermediaries 2021. Both of these have provided the same safeguards. The provisions are identical for the procedural safeguards. Rule 9 of the IT Rules 2009 and Rule 16 of the IT Rules 2021. They both provide a mechanism for emergency notifications. Firstly, the petitioners would contend that there is no emergency, but the rules provide that in case there is an emergency and the central government feels fit and it feels that it is necessary and justified and expedient, on the same grounds that are listed in section 69A, they may provide a blocking order. It also provides specifically that this blocking order will be an interim order until it is approved by the review interdepartmental committee within 48 hours. It specifically lays down a timeline. If I could direct the Lordship's attention to para 6 of the Moot proposition. Para 6 of the Moot proposition clearly states in the second line, though the MIB claimed that the review committee approved the decision post facto, RTI applications filed by civil society groups revealed discrepancies in the approval timeline. Clearly, the approval timeline of 48 hours was not met, Your Lordships. As the Moot proposition clearly states, the RTI applications have shown that the 48-hour timeline was not met. In Hukum Chand Sham Lal, where the court was looking into the interception orders under the Telegraph Act, the court held that when an authority is given a power to be exercised, it must be exercised in the mode that is prescribed, and any other mode is forbidden. Especially when that power is of a drastic nature, then any mode otherwise would be a violation of the fundamental principles of natural justice. In that case, it was only about interception. It requires that body order rule. These violation of these procedural safeguards is procedural arbitrariness in action and violation of Article 14. Moreover, Your Lordship, it would be submitted that
Mentioned that things to be done in a particular way, it should be done only in that manner, not at all.
Indeed, Your Lordship.
You kindly tell us which is the root case of that principle.
Hukum Chand Sham Lal.
That's
Is
later. Taylor versus Taylor.
Yes, Your Lordship. Thank you.
And King Emperor versus Khwaja Nawaz for the Privy Council. Taylor versus Taylor is
Indeed, Your
the
Lordship.
19th century case.
Much obliged, Your Lordship. Your Lordship, the second prong of the argument is that it does not meet the proportionality standard that this court has upheld in Puttaswamy. That there are three prongs, that there is a legitimate aim, that there is a rational access, and that the least restrictive measures is utilized. In this case, the least restrictive measures were not utilized.
Which according to you, in fact, that's what I wanted to ask in the earlier round, which according to you would be a lesser intrusive?
Indeed, Your Lordship, there were multiple streams of avenue that they could have followed. The government could have put a disclaimer if they believed that this was not disclaimer, Your Lordship, if they felt that this was not appropriate or this was not true information. They could have put age restrictions when they made it mandatory only for adults if they felt that this was content that was not suitable for kids. Or they could have censored only portions of the documentary which they felt was incendiary or which they felt was revealing confidential information. But a blanket ban is the most oppressive tool available to the government, and that is the one that they have chosen to go by. Your Lordship, thus experience.
Is it possible present days in the advancement of technology?
Your Lordship,
Is it possible what you are suggesting?
Your Lordship, under the Cinematograph Act, the government has the power to censor portions of the films if they are before going into public screening. Your
No,
Lordship.
this is not on film it is being shown. It is private circulation right.
It is published online, Your Lordship, over the OTT platforms, Your Lordship. The government could have spoken to the.
So at that point, it's then available to everyone, isn't it?
Yes, Your Lordship, and before blocking it, before reaching the most extreme conclusion, Your Lordship, the state could have taken up less restrictive measures, Your Lordships. They could have put some notification, as Twitter has notified.
We are putting up notification which is sufficient.
Your Lordship,
Hundreds of notifications are put every day.
Your Lordship,
Smoking is dangerous to health. Simple, I am giving you example.
Your Lordship,
How many people are stopping?
Your Lordship,
And how many cancer patients are going? See, that is no use with mere notification. Unless some strict action is taken, preventive measures are taken, nothing happens in our country.
Your Lordship,
Unfortunately.
this has been taken using the most extreme method. They have also used it using the emergency notification under the IT rules. If they had done it by the regular notification, they would have given them a hearing. They would have to give them a notice before they were blocking it.
Could they wait? Because there are already violent incidents are taking place.
Your Lordship, the petitioner
Should they wait till somebody dies or some people are properties are damaged, and which has happened already?
Your Lordship, Article 352 or 356 was not imposed. There was no question of emergency. But even in this, but yes, Your Lordship, but
Thank God it is not done, you must be grateful.
yes, the contention of the petitioners is that it is not an emergency situation. There is only property damage in two localities, Your Lordship.
Is it something
And
not important?
indeed, Your Lordship, that is a local law and order issue that we respect and we understand states need to take action. But to ban it across the country on the basis of those two issues is extreme.
No, both of you are only concentrating on property damage. I am on communal tension.
Yes, Your Lordship, but
That may explode any time and may happen anything.
Your Lordship, but communal tensions is
So
not
should the government wait, let something happen and then we will take action? No. So that is why preventive detention law is there, to prevent beforehand.
Your Lordship, but communal tensions cannot be a blanket justification if there is no specific measure of what is the communal tensions and whether there is an urgent necessity where it will explode into communal violence, Your Lordships. It cannot become a blanket justification for imposing a blanket ban across the country on documentary, Your Lordship.
Again, who is to judge the kind of communal tension and what measures?
Which may
I think it is the responsibilities of the government, whichever it is, the government of the day has to take care of it.
Your Lordship, in Indelibility Creative versus State of West Bengal, a recent case, speaking for the Supreme Court, was looking at a satirical film from West Bengal, which was causing protests and riot-like situation. The court said that the Article 19 imposes not just negative this, but a positive obligation on the state.
No, question is different.
Yes.
Who should judge that?
Indeed, Your Lordship.
Pointed question, pointed answer.
Yes, Your Lordship. Who should judge? The state is the judge of when is an emergency.
That is the judge, right?
Yes, Your Lordship.
Perfect. If you go for balance of interest, you would like to look at the liberty of an individual, suppose you hit it, or the community, the whole community is going to suffer from it. Or the state, the government, the state as such is going to lose its credibility or whatever, it's an international kind of thing. How do you balance it and who should balance it? Who should be the judge?
Yes, the state has to be the judge, but the judiciary has to step in when the state makes the wrong decision and
Judiciary comes later.
Yes.
When you challenge it, the order of the Decision shall be taken.
Yes, Your Lordship. The state,
Ultimately, a decision has to be taken, that's not by the judiciary, that's by the executive.
yes, Your Lordship. The state has this, but the question is whether the state's actions are proportionate, Your Lordship. When it proves the submission, it is not. In indelibility created, the court held that there is also a positive obligation on the state to protect the right to free speech. That in that case, when there were threats to the cinema goers, the court held that the state has a responsibility to protect that film and to allow the freedom of speech and expression by not curtailing the speech, but instead protecting the film from the grounds that were against it, Your Lordship. Finally, Your Lordship, last submission that the IT Rules 2021 have been stayed by the Bombay High Court in against promotion versus Union of India, holding that the Code of Media Ethics is ultra vires the Parent Act and violative of Article 19 Clause 2. This stay has been upheld even by the Madras High Court, which said that it had a pan-India effect.
Not before the Supreme Court. So.
Yes, Your Lordship. The only question is that if the IT Rules 2021 have been invoked to ban this, then it is a violation of that stay, Your Lordship, and thus it would be a violation of not just judicial authority but rule of law, Your Lordships. That would be the submissions of the petitioners. It has been a privilege, Your Lordship.
So any observation on para 14?
Your Lordships, on para 14 and some questions.
Can the petition justify?
Your Lordships, it merely
It's a
mentions
fact. See, para 14 is a fact.
Your Lordship, it merely mentions certain activist groups. Like in a large country, I'm sure there are some certain activist groups that have received foreign funding, and it raises questions about compliance. It does not merely state whether there is compliance.
There is an attempt to destabilize the government
System.
Possible system.
Your Lordship, under the FCRA, they are allowed to get foreign funding with registration, Your Lordships. So they have not clearly stated whether the compliance is met or not. They have just said raising questions about compliance, Your Lordships. So if they have done it through the FCRA mechanism with compliance and registration, it would be legal, Your Lordships, to receive that foreign funding. And it is not mentioned whether these parties are also parties before this honorable court.
No, that they need not be parties here. These facts speak for themselves.
Yes, Your Lordship, the parties who have come before this court are bona fide parties who have been agreed, like Abhinav Sharma has been agreed. They are bona fide parties who are seeking the right to access their information.
That's all. We are not questioning your bona fides.
Yes, Your Lordship.
No one said that the petitioner has not come bona fide.
Yes, Your Lordship.
The question is whether you have made out a ground and whether that would entitle you to any relief. No one has questioned your bona fides. Why do you get that information?
Much obliged, Your Lordship.
Now, God would like to know one point.
Yes, Your Lordship.
Whether the state government has got the power as well as the duty to act in a situation like this.
Your Lordship, it would depend on the actions that were taken.
No, whether it has got power as well as the duty to act, to protect the nation, the system, people, property, public order, what?
Indeed, Your Lordship, they do have their
That is the constitutional obligation, Article 92.
Indeed, Your Lordship, there is. But Your Lordship, the question is whether these actions were proportional and whether they were the least restrictive measures applicable, Your Lordship, and petitioner's contention is that it is not. It has been a privilege, Your Lordship.
So, okay. What about 69A?
Your Lordship, I was discussing 69A and the IT rules under it, Your Lordship.
Who will take it?
Your Lordship, the submissions were regarding the 69A and the infringement also, Your Lordship. And Your Lordship, as I submitted, they were in infringement
I have
already.
one question.
Yes, Your
So
Lordship.
far as this act is concerned, Information Technology Act is concerned,
Yes.
what kind of act is that? What kind of interpretation is that? Is that a strict interpretation? Literal interpretation?
Your Lordship.
Or beneficial construction?
Your Lordship, it
In
is.
favor of the petitioner?
Your Lordship, it is both a penal and preventative statute. So the question of interpretation is up to the court, but the court.
No, there are settled
For
rules.
penal,
There are settled rules. There are settled rules.
Yes,
As
Lordship.
far as interpretations are concerned.
Interpretation of penal and taxing statutes are strict interpretation. I understand as far as I understand, Your Lordship. Since it is a penal statute imposing offences, Your Lordships, it would be a strict interpretation.
You mean this Information Technology Act is a penal statute?
There are offences listed in the Information Technology Act, Your Lordship.
There are
Maybe
offences.
offenses
Yes.
listed down, but does it make it a
That's
penal statute?
Is that a penal statute?
But Your Lordship, Section 69 in Ex Corp versus Union of India, the court looked at Section 69 and said it was both penal and preventative in scope, Your Lordship.
Even in Income Tax Act, there is a provision to punish the person. Could you call it Income Tax Act a penal act?
It's a taxing statute.
Is it true? Even in the Motor Vehicles Act.
Your Lordship, it would be advisory.
Then to bring the case, how do you classify? Where does it come?
Your Lordship, we have to take a purposive interpretation of this. Your Lordship, like the purpose of it being preventative in nature, it must be like in anticipation of danger. There is no danger from this content, Your Lordship. Lordship. Much obliged.
Ultimate prayer.
In light of the issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court that this honorable court may be pleased to hold a judge and declare that the preventive detention, surveillance, and unauthorized seizure were violative of the Constitution, and further, the issue of writ in the nature of mandamus, quashing the blocking orders under Section 69A of the Information Technology Act 2000, or pass any other order or orders that may deem fit in the interest of justice, equity, or good conscience. For this act of kindness, the counsel for the petitioner shall be forever free.
So that something would have gone to High Court. Why they came to Supreme Court in Article 32?
Indeed, Your Lordship, we understand that the High Court also has jurisdiction, but we believe this is a matter that the presence of alternative remedies by themselves do not bar the jurisdiction of this court. And considering that in preventive detention has occurred in multiple states, we felt that it was necessary to approach this honorable court having jurisdiction under Article 32, and there is a violation.
Jurisdiction is there.
Yes, Your Lordship.
You say there is no trust with High Court?
Indeed, not, Your Lordship. We do believe in the High Court systems, but Your Lordship, we approach this honorable Supreme Court because we believe these are violations of fundamental rights of all citizens across this country, with regard to the blocking of the documentary across the country, Your Lordship.
Of course, that was the wrong thing.
Because according to you, it has implications all over.
I know, moreover, it's not for the court to decide, it's for you to decide, because the right is vested in you.
The logic is that all the retributions will come, then what is the work for the High Court? So that is the reason is not mindset that go before the High Court. Now, under 69, if any violation of the IT Act, there is appellate tribunal.
Yes.
Appellate tribunal under the IT Act.
But not the violation of fundamental
No,
rights.
it's a public order, any tranquility is disturbed in the state, any place, it is a state government is a crime against the state. That's why the state government is entitled to make preventive detention order, and preventive detention order was, the act was challenged, which is the first case which was challenged, the preventive detention.
A.K. Gopalan,
Yes, Madras. State of
That
Madras.
was under 32.
Yeah.
Not in the High Court. So that this court has constituted the site to know why do you say that?
And just to put it, it's article.
Yes, Your Lordship. Thank you much, Lordship.
Yes, yes.
Council 6 function for facts.
You are appearing for Union of India.
And others, Your Lordship.
Who are the others?
Respondents.
Who are the others?
May I address the bench as Your Lordship?
Yeah.
Your Lordship, the others in this case would be the Ministry of Information and Information and Broadcasting that have issued the 69A issuing blocking
That's
orders.
not the Union of India.
In what capacity you are appearing?
Lordship, we are the respondents for the Union of
How
Belmont.
you are?
Yes, Lordship.
How you are? In what capacity you are representing Union of India?
Now, the one minute. Petitioner has filed writ petition against whom? Against whom? Who is the respondent? Respondent or respondents?
Respondents, Your Lordship.
Respondent.
Yes.
Who are they?
So Union of Belmoria,
Who is the respondent of one?
Union of Belmoria,
Union of India.
Belmoria. In this
Union of India.
in this present case, Belmoria is parameterial.
Equivalent.
Yes, Your Lordship. Your Lordship.
So you are representing respondent.
Yes, Your Lordship.
What is the designation?
In what capacity? This is what exactly I am asking right from the beginning.
So
Are you Advocate General?
Oh, okay.
Attorney General.
I have put words in the mouth. You must state that you are representing state under this designation. Or even private can be doing.
Yeah.
We have no objection. We just wanted to find out whether you are Advocate General, Attorney General, Solicitor General.
Additional Solicitor General.
You are the Advocate General for the.
You are Advocate General for the state.
Yes, Your Lordship.
Okay. Good.
Your Lordship, I am the counsel number 1 for the respondents, and I will be dealing with the issue number 1, and my co-counsel will be dealing with issue number 2 and 3. Your Lordship, the present issue questions whether preventive detention, alleged data privacy breaches, and restrictions on public screening infringe upon the right to privacy and personal liberty under Article 21. Your Lordship, the state is, the respondents is humbly submitting before this honourable court that there has been no violation under Article 21, and the same will be contended by the council in a threefold manner. The first one being that the preventive detention that have been taken has not violated Article 21. Your Lordship, preventive detention has been upheld in the case of has the Supreme Court upheld the validity of preventive detention and has clarified the same in Manika Gandhi versus Union of India and others in the Supreme Court judgment of 1978. It reaffirmed the
Manika Gandhi has nothing to do with preventive detention.
Indeed, Your Lordship. It was upheld in A.K. Gopalan versus State of Madras.
A.K. Gopalan is
It was confined to
no
detention, that's all.
Yeah.
There is no more law.
Detention under preventive detention.
Indeed,
A.K.
Your Lordship.
Gopalan is no longer good law now.
Your Lordship.
Yes.
Yes, Your Lordship.
Manika Gandhi case was said.
Yes, but Manika Gandhi
1419 is
is
attractive.
detention.
Indeed, Your Lordship.
Manika
Manika Gandhi.
Gandhi was passport case.
Indeed, Your Lordship. The reason why the council put forward the Manika case was to ensure that contend that the procedures that have been followed were set in Manika Gandhi should be fair, just, and reasonable. And the same has been followed by the state. Your Lordship, in Anuradha Bhasin versus Union of India as well. The Supreme Court, Anuradha Bhasin versus Union of India, the Supreme Court in 2020, it recognized state has the responsibility to take care of the public order of the state and can take any actions when there is an apprehension of danger.
No, Council, one question.
Yes, sir.
Merely because the documentary tried to show certain lapses on the part of the government and some rights or whatever it took place. Was it not your state duty to prevent it? And instead of that, you go for a preventive detention act?
Indeed, not, Your Lordship. When we are talking
Because
about
your responsibility to take care of the maintain the peace and order.
Other laws, criminal laws can.
There are other laws, and straight away you go for drastic action.
Your Lordship, in the present case, if I may refer to the para number of the fact sheet, that is 7. Your Lordship, here preventive detention has been taken against the students who were given the orders of Section 144 CRPC. And when we look at para 8, Abhinav Sharma and the students who were detained later were only detained, not preventive detention. Para 7, when we talk, that is after the Section 144 has been imposed, a magistrate order has been imposed on the petitioner's lordship, and after that, when it has been violated, that is when preventive detention has come forward. Your Lordship, the grounds for preventive detention under Ramanohar Lohia. One second. Yes, Your Lordship.
Please, state may have the power to do it.
Indeed.
I don't think anyone denies the power. The question is the exercise of power
Reason
justified?
arbitrary.
You have to justify that.
Indeed, Your Lordship.
How do you justify?
The same can be justified under Article 22, Clause 5 of the Constitution.
Parameters of that. You have to justify it on facts of your.
Yes, Your Lordship. So in the present case also, Article 22, Clause 5 talks about how the reasons has to be communicated to the petitioners while they are being detained.
That's the procedure.
Indeed, Your Lordship. So when the procedure is being followed, when there are public order concerns, as rightly mentioned before, there are communal tensions and property damage that have been in several cities, not just one. In those cases, when preventive detention is to prevent something, Your Lordship, when it is may have harmful effects or
It is a last
restriction.
stage, last step to be taken always. Preventive detention step is a drastic step.
Your Lordship, when we say preventive detention, that is to prevent something. And
And whom are you detaining? It's not some regular
indeed, Your Lordship.
parents who indulge in arson, riots and all that. He's a student.
Indeed,
He's
Your
just
Lordship.
passing some idea.
And one of their part just to screen.
Yes.
That's all. Peacefully to screen the documentary.
And free marketplace of ideas.
That's all.
Yes.
Indeed, Your Lordship. But when we talk about the documentary that is being screened in this particular case, that has been blocked under the by the Ministry of Information and
That's exactly that blocking itself is
Your Lordship,
question.
the reasons that
with the freedom of speech and expression, which is the very substratum of the democracy.
indeed, Your Lordship. When we are talking about the blocking itself, Section 69A by the Ministry of Information and Broadcasting, the reasons that they have given that is proved under this present case, as there is threat to national security and public order, there is a possible diplomatic fallout, there can be apologies, there is a potential to incite communal disharmony. So when these reasons are present, that is when 69A has been put forward. And when there is a ban or blocking order on the documentary, it is incidental that when you screen the documentary itself that is already blocked, then there will be actions taken against it. And when we talk about preventive detention, under para 7, preventive detention is against the when they violated the orders of the magistrate under section 144 of CRPC.
69A requires subjective satisfaction. What is the material to show that you had subjective satisfaction that such a thing is going to happen?
Subjective
Because you are
satisfaction.
taking very serious action.
Your Lordship, the same reasons, if I may briefly contend for why were the reasons why were the 69A put forward in this case, or the blocking orders were present. However, my co-counsel will be breaking down each reason and establishing the
Do you
same.
have anything with you? Because only you would be in the know of it.
Yes, Your Lordship. So when we talk
Not
about
raised objection for maintenance of the petition. There are no objections for maintenance of the petition.
No, the memo they have said it is explicitly conceded. That
Yes.
rightly so.
Your Lordship, so when we talk about the reasons given under Section 69A, there is national security, Lordship. National security as national
What is the
security.
rule in respect of 69A?
The rule, Your Lordship, that is 16.
69A.
2009.
That is regarding IT.
2000.
IT rules.
Yes, Your Lordship.
2021 intermediary.
2001.
2009. The blocking orders that has been.
No, we are 2021.
Your Lordship, 2009 IT rules. Rule 9 of the settlement.
What is that?
Could you read that rule?
Yes, sir. Blocking of information in cases of emergency. There is a whole, the first subclause, Your Lordship. Notwithstanding anything contained in Rule 7 and 6, the designated officer, in any case of emergency nature, for which no delay is acceptable, shall examine the request and printed sample information and consider whether the request is within the scope of subsection 1 of 69A of the Act, and it is necessary or expedient and justifiable to block such information or part thereof.
Exactly, this is what I am asking.
Indeed.
What is the material to show that officer, concerned officer has applied his mind?
Your Lordship,
You can't take arbitrary action just you feel like taking 69A. There must be something. What is the material
Your
to
Lordship,
show that you have considered?
Your Lordship, the material that has been considered here are the reasons that have been put forward under 69A. And when we talk about these rules also, blocking order procedures also, Your
You mean to
Lordship,
say we have to accept 69A? That's all is your
Indeed not, Your
satisfaction.
Lordship. the 69A reasons will be dealt to the co-council, or I can also brief you with the reasons and apply it on present case.
You said there's a potential and there's a possibility. So he's asking what is the potential, what is the possibility in light of the facts. That's
Under the rules, what subjective satisfaction you have done? What is the material before us?
Your Lordship, if I may refer to the facts and articles here. Your Lordship, when we talk about national security, it deals with social political stability as well. When we see the case of Madhyamam Broadcasting Limited versus Union of India, here, Your Lordship, there has been a political instability.
I don't think any case will help you because it's some facts. How you, that is the competent authority, has come to the conclusion.
Indeed,
To
yes.
show that there is subjective satisfaction before initiating any action. Subjective satisfaction.
Yes, Your Lordship. In this present
That
case,
only you must be able to tell the court.
To government, because you are the one taking action with that.
indeed, Your Lordship. Your Lordship, in this present case, there, as mentioned before, there has been sporadic protests not just in one state but in several cities. And demonstrations have turned violent in two of the cities, that is Jaipur and Malanpura. Further, Your Lordship, in the present case, within a short amount of time, several protests have ignited and have led to further damage. And Your Lordships, the restrictions are reasonable as the even on the platforms, it has been restricted to only few platforms, that is Netflix, Twitter, and YouTube. And still, discussions are available for the petitioners to. It is only the screening that is banned and the documentary that is blocked. However, they can still use the other freedom of speeches, that is in writing, in discussions. They can use all this and still express their freedom of speech and expression. Your Lordship, if I may take 1 minute to.
No. Yes. Preventive, when you say preventive detention, when a person is put under preventive detention, it has got far-reaching effects. It deprives him of other fundamental rights also. Right? Right or wrong?
Your Lordship, it was said when preventive detention may limit the liberty of the petitioners, but it was for the public good and for the
That's
public.
justification. The question is, as a fact, does it not curtail your liberty?
It does. It's indeed, Your Lordship.
Affecting 19.
Yes.
So many,
Other rights.
So many others.
So many rights. What is the answer? What is justification?
Your Lordship.
Whether it's proportionate,
Yes, Your Lordship.
deprive so many rights for this reason. Is it proportionate?
Your Lordship, it has not. This is the state, the respondents have reasonably restricted the same for the public good and to save the public order and to national security. It may look like it has infringed, not infringed, but limited on the rights of the petitioners. But however, that is reasonable under this case, Your Lordship. The reasons were cited to the.
Okay. My another query. Though this section gives power to take a decision on subjective satisfaction, don't you think there should be an element of objectivity also?
Yes, Your Lordship.
What is the objective?
Meaning,
Yes, please.
is the Lordship asking about the nexus between the object and the means achieved? Your Lordship, so the privacy breach is also in this case. When we look at the Puttaswamy judgment, they have put forward the three-prong test.
Which test?
Prong
You are
test.
concerned with proportionality test.
Indeed, Your Lordship, and
This
it's
is proportional.
And what my lord asked you, should that not be an objective standard, even for subjective satisfaction? 60 years ago, in 1967, the famous barium chemicals case,
Yes.
subjective satisfaction by certain settled objective standards. It can't be subjective satisfaction according to my will.
That means arbitrariness.
Yes.
Your Lordship, if you go by the test, Your Lordship, there existed legality. When we look at the narrowly tailored reasons that have been used, the council is aware that the DPDP Act has not come into force. However,
We are not concerning the DPDP Act.
okay. Indeed, Your Lordship. Then, Your Lordship, there is a definite state aim. There is a definite state aim as well, Your Lordship. It's to protect national security. Your Lordship, when we talk about the definite, legitimate aim as well, when if may I refer the para number 14 of the Moot proposition. The FCRA, that is Financial Contribution Regulation Act, has also been violated, Your Lordship, when the funding is given to activists supporting public screening. Your Lordship, in this case also, the state has a legitimate aim to restrict such activities, Your Lordship.
Okay, is that
This act may have been violated, but would that invite preventive
Detention of students.
whatever
Indeed not, Your Lordship.
law will follow, but why preventive detention and that too of students?
No, preventive detention is a different issue.
And they
As
are
I have
not protesting or holding protest. They just wanted to screen some document.
Indeed, Your Lordship, the council was putting forward the FCRA argument for only the privacy breaches, and privacy breaches the test that there exists a legitimate aim. For the preventive detention, this was not the argument, Your Lordship. The arguments for preventive
Aim for what? No, we were not asking you about preventive detention to justify it.
Okay.
How do you link this with this? Sorry, maybe you'll be able to enlighten us.
Apologies, Your Lordship. I was explaining the privacy breaches and not the preventive detention. For the preventive detention, Your Lordship, the contention is that the reasons have been cited to the petitioners. Reasons have been cited, and the representation is also allowed, as therefore complying with the procedural safeguards of the preventive detention under Article
And you
30.
should notice to them. And once you can,
Your Lordship, the
they
reason.
don't know. Suddenly you take the action.
Your Lordship, it does not require a notice, but only the reasons to be communicated, and that has been done by the.
No, that should have been treated to file.
Yes, Your Lordship.
That's not the question.
May I listen to the question on the motion?
Preventive detention.
No, that's not preventive
Not for
detention.
preventive detention. Yes.
Okay.
When you notice all these problems,
Yes.
did you notify them and ask for their views, explanation, whatever you call it?
Absolute justice.
Actual business.
For
Or you
preventive.
just straight away hit the final step.
Your Lordship, may I confirm?
Absolute justice.
Yes, Your Lordship. May I? Your Lordship, under 69A also, when it comes to emergency situations, there is there is to be a notice with the reasons to be in writing that has been done by the Ministry of Information and Board. So, yes, Your Lordship, the reasons have been cited and written in writing for the petitioners in this case. Your Lordship, as may I refer to the last, or should it proceed with the next case? Next comment?
Yes. Yeah, your book comes.
Okay.
Unless you have anything more to tell us.
To positive time, Your Lordship, I don't.
Yeah.
I want to take 1 minute time, no problem, we can try.
Yes.
Just the
You are not
last.
very point.
Yes, Your Lordship, just the last point.
Yeah, please.
Your Lordship, as I did not get to refer the public screening restrictions that were and how they are not violative of Article 21. Your Lordship, in this case as well, we go by the reasonable test that is Modern Dental College and RUAS versus State of Madhya Pradesh, and that there was a proper purpose, there were measures taken, and measures were necessary, Your Lordship. And even Section 144 in this case will be held valid, as I mentioned before. The magistrate puts in the material facts, the reasoning, and there is a prior inquiry before the blocking prohibitory orders are issued by the magistrate. That's all.
So the government convinced of having present and imminent danger of the situation. To take this action, the government was convinced of visualizing a present and imminent danger.
Indeed, Your Lordship, when we talk about
No,
Section 144.
you had present and imminent danger there.
Your Lordship, when we talk about there was imminent danger, and there can be threat.
How could you find that present and imminent danger?
Your Lordship, as I mentioned in the facts of the case, there was.
No. Not consider the facts.
Yes,
As a proposition.
As a proposition. Proposition.
Your Lordship.
How to mention? How to mention? What one? Yes, this is no. There is fact. The present and imminent danger.
Your Lordship, to the best knowledge of the council,
When this document was developed, when this proposition was developed.
The council is not aware of this. Your Lordship, but to the best knowledge of the council, imminent danger would be when the public.
If the council does not know, no problem. We respect that. Fine.
Yes.
Next we can take up.
How much of that?
The council seeks permission to approach the dais.
The council seeks permission to address the bench collectively as a lordships and individually as a lordship and ladyship. Much obliged. Your Lordships, I am counsel 2 and I will be dealing with the second and the third issue. The second issue deals with whether the blocking orders issued under section 69A are constitute a reasonable restriction under article 19 clause 2 or are they in contravention of article 19 clause 1 subclause A. Before the council proceeds with the submission, the council would like to answer the question posed at the co-council whether given that section 69A is a test of subjective convenience, shouldn't there be something objective posed with the section itself? That was a very valid question, Your Lordships. However, the objective test which can be put in such cases is whether it follows the due process of law or not, which was upheld in the case of Maneka Gandhi versus Union of India. Your Lordship, for due process of law, any procedure established by law should not infringe Article 14, 19 and 21. In Section 69A, the constitutional validity of Section 69A was upheld in Shia Singh versus Union of India on the grounds that there are certain procedural safeguards in it which ensure that it does not violate the said fundamentals.
Whether adopted the procedure established by law or due process of law.
Indeed, Your Lordship, there are two different things. The verbatim mention is of procedure established by law. However, the Supreme Court itself has also identified due process of law in Maneka Gandhi versus Union of India and said that it's a part of the basic structure. The due process of law is basically the principle of the golden triangle, which is 14, 19 and 21, which means all three of the fundamental rights should be respected. Any reasonable restriction
I don't think we should go that far on. The question that was put was very different. You are talking the constitutionality of the provisions. Fine, they are granted.
Only of the section 69.
Yeah, that's right. That's a help. The question that was put is for you to take government to take action.
Indeed, Your Lordship. I will deal with that.
That is the subjective satisfaction.
The subjective satisfaction.
Area on which you can say that you were satisfied by some objective standards that this action was absolutely necessary.
Indeed, Your Lordship.
That's a simple question.
Indeed, Your Lordship.
The higher readings of law.
Indeed, Your Lordship. Indeed. So, to begin with, in Modern Dental College and Research Center versus State of MP, the court laid down a four-pronged test of proportionality.
Sorry for interrupting you, but all this is law. We are aware and we grant you what you say.
Indeed, Your Lordship.
The question was if you would answer, and if there is any problem, we can proceed further. The question was when you have to take the competent authority has to take action, that is the subjective satisfaction.
Indeed, Your Lordship. Indeed. I was dealing with the state material.
Satisfaction must be based on some material.
Indeed.
I cannot just get up from my dream and say I went yesterday and therefore this person must go to jail.
Indeed not.
Yes, therefore there must be some material and that must be by certain objective standards. That's all the question. If you have something to enlighten us, please do.
Your Lordship, I will be dealing with the exact same thing. I'm merely stating the objective standards that were laid by the Honorable Supreme Court, and then one by one I'll be dealing with all of them, if you remember. Much obliged, Your Lordship. So the fourth-pronged proportionality test that was laid down in the case was first that the restriction must serve a legitimate state aim. Second being that there must be a rational nexus between the restriction imposed and the state aim. Third being that it has to whatever measure has been imposed has to be least restrictive in nature. And fourth being that it should not cause any disproportionate harm. Your Lordship, in the instant case, there is a legitimate state aim. The state aim which has been cited by the government by issuing the blocking orders was first that there is a threat to national security and public order. Second being there is a possibility it might incite communal disharmony. Third being that it poses harm to diplomatic relationships. And fourth being Fourth being that there is a possibility that the content is defamatory in nature and seditious in nature. Your Lordship, if I may draw the attention of the court to flag number 13 of the complaint. I'll be dealing with that, Your Lordship. In the fourth submission, I'll be dealing with the same. Your Lordship, if I may draw the attention of the court to flag number 13 of the compendium, in Ministry of Information and Broadcasting versus Cricket Association of Bengal. Your Lordship, as the counsel for the petitioner has stated that they have a right to viewership, right to receive information, and right to disseminate the said information, which was stated in the said case. However, in the same case, it was also stated that the same right is also subject to the same reasonable restrictions under Article 19, Clause 2. Your Lordships, the proportionality of the impugned restriction vis-a-vis the blocking orders under Section 69 can be justified in this manner. While they have a right to receive the information, there is also a duty on the state to ensure that there is no spreading of misinformation. Any sort of misinformation that can cause harm to public order or cause any threat to national security. The same was upheld in the case of Amish Derbin versus Union of India, a 2020 Supreme Court judgment, where they have cautioned against the spread of misinformation that could incite enmity between communities. While the instant case where the proposition does not really state, as your Lordship has wisely stated, that communal tensions are only the first step towards communal disturbances or communal violence. However, your Lordship, the council would like to point out this might work in a ripple effect. As your Lordship has already stated, that these communal tensions might at any point take a turn which we are trying to prevent already. Counsel for the petitioner very fleetingly made a statement that in a country like India, communal tensions are very common. However, the accountability of the same is always the petitioner, the counsel for the petitioner, not in the proposition, your Lordship, in the course of argument.
No, okay, use the word India. I think.
No. That's exactly what I would like to clarify, your Lordships. The counsel for the petitioner, indeed, your Lordship, indeed. The counsel for the petitioner has time and time again referred to multiple circumstances which were in India, not in Bengal. While the proposition clearly states that the laws are pari materia to India, they also state that the facts of the case are merely fictional. They are not pari materia to any country.
What happened in India may not happen in Bengal. That's all.
Indeed, your Lordship. However, the council also made a very fleeting statement that in a country like this, communal harmony, communal tensions are always present. However, your Lordship, the accountability for the same has always been forced on the government. That it's the government who's supposed to take actions when there are communal tensions, or it's the government who's supposed to make sure that such tensions don't escalate into something more violent. And the government did the exact same thing in the instance.
No, but you can't straight away take drastic step of
Indeed, your Lordship. Indeed, absolutely.
You have done this in this case.
Indeed, your Lordship. However, the restrictions that were taken by the government were already the least restrictive measures in nature. Why? Because first, your Lordships, as it has already been stated in the proposition, paragraph 4, in the proposition, that there was the advisory by council. In paragraph 11 of the proposition, it was stated that there was an advisory issued by the Press Council of Bengal stating that there are certain concerns about the journalistic ethics in the documentary's production, particularly the use of undisclosed sources and edited footages. First. Secondly, your Lordship, it has also been clear that there are certain unverifiable resources that were used to make the documentary. Furthermore, your Lordships, when we talk about the material of the documentary itself, while paragraph 2 tells what the documentary, what were the certain sources that were used, we don't know the nature of the source.
Paragraph 11 itself shows that you are concerned with your safety. That's all.
Concerned with, sorry, your Lordship?
States your whoever is the ruling party or whoever it is.
Your Lordship, indeed not, your Lordship.
They wanted to stop that. So take drastic action.
Indeed not, your Lordship.
That appears to be so.
Indeed not, your Lordship.
Because there was a move for draconic censorship against government, against the government. So you wanted to prevent it, passing a draconic law. That's all. It appears to be.
Indeed not, your Lordship. Section 69 made by its very nature is an interim order, which means it's temporary in nature. It is always, the blocking orders were only issued for a particular time. They're temporary in nature. They were issued
only to make sure that while the country is already in a sensitive state, the tensions which have already taken place don't further escalate into something which might be more detrimental for the security of the state and for the public order of the state. And therefore, these steps were taken. The only way in the instant case to stop the dissemination of misinformation was to block the pen drive. However, the government has not stopped anybody from having discussions over this. They can still have their writing pieces if they want. They can still have discussions over the public screening. They can still have discussions over the very riots which took place in 2000. The only restriction that they've imposed is blocking orders issued against only few sources, only few social media platforms or screening platforms which are Netflix, Twitter and Facebook. Only on a few platforms, just to make sure that misinformation is not disseminated. Your Lordship?
See, that's why it was only for a limited purpose and limited people or entities it was issued, blocking order. Students are not part of that. They are independent students, they want to look into it, decide, consider, put forth their views.
University.
Yes, it's a very big issue on that. Yes, upload that. Yes. No, okay, it's even if it is accepted, the government, okay, decision, on some apprehension, fine. You stop the release of this show or whatever. Why that preventive detention?
Like the preventive detention.
Why that? You want to stop it? Okay, stop it.
Yeah, that is dramatic enough, but
Okay.
I think that
Okay. Even for that. Fine. Yes, decision is taken. Accepted. You block the way and we accept it. But why to prevent? We are going to go for preventive detention. That too of a student.
Your Lordship, preventive detention in the instant case, if I may draw the attention of the court to paragraph 3 of the proposition, it says that, Your Lordship, I mean paragraph 7 of the proposition. It says that several student bodies and activist groups attempted to organize public screenings in the university campuses, in response to which the state had already issued prohibitory orders under section 144. There were already prohibitory orders against a certain action. That was for the public screening of those. Following which, the students and organizers in some states were detained under preventive detention.
They actually, suppose if they breach section 144, take action for that.
Was issued 144 order?
144 order was issued.
Issued.
Indeed, Your Lordship.
Who has issued that order?
The state has issued the order.
No, state did not issue. You don't know.
The state government in Mistara and Pradesh issued prohibitory orders.
Who will issue a 144 order?
Lordship, the fact says that the state government
You should know.
You are a law student.
The magistrate does it.
Ultimately, state, all right. Who
Indeed.
represents the state in the district?
the government does not issue that order.
Indeed, Your Lordship.
144, just for your knowledge purpose and because 144 order CRPC. 144 means the CRPC.
Indeed.
Old CRPC. Who issued that order?
The
Is it
magistrate.
Chief Secretary or
The magistrate.
Which magistrate? Which magistrate? No, which magistrate?
Judicial magistrate?
Judicial magistrate.
Wrong.
Magistrate first class, JMSC.
District magistrate.
Executive magistrate, district
District magistrate. How many magistrates are there?
So not
How many magistrates are there?
144.
JMSC,
How many
JMSC.
magistrates are there in the under?
Okay.
Okay.
It's the executive, it's not a judicial
Executive
order.
magistrate.
Judicial has nothing to do with it.
Executive magistrate in the taluka, district magistrate, subdivision magistrate and tahsildar. He is also executive magistrate. All these three persons are meant to prevent tranquility in the area within their jurisdiction. They are all executive
Executive
magistrates.
magistrate.
Executive
And
magistrates.
how do you apply
No,
section
no, no.
144 in the present case?
124 in the present.
144.
144.
CRPC.
You know, sir, it was for the orders under 120 section 124 were prohibitory orders.
144.
Yeah, 144. Indeed, Your Lordship, 144. This orders under section 144 of CRPC were issued to block the public screening of the gathering of the people for the public screening of the said documentary. And why it was done is exactly what the council is dealing with in the second issue. That is, the contents of the documentary were such that they could have posed harm or posed threat to the national security, public order.
You mean to say unlawful assembly?
Not, Your Lordship, unlawful
No,
assembly.
no, one thing, people are going there, they are found. You see unlawful assembly and interpretation of that. People
Indeed,
go
Your
there,
Lordship.
assemble, but it is lawful. But subsequently it becomes unlawful because of the violation, tranquility or.
Look into section 144 if they have. It may.
So there they say, when the lawful assembly becomes unlawful assembly.
May become the possibility of it.
There is a possibility.
That's why it's a prohibitory order. It prohibits something from happening beforehand. Your Lordship.
So that stage is not reached here.
Your Lordship,
They ask the permission to screen, and then the university refused. So they were holding a peaceful procession.
Your Lordship,
That's all.
Indeed, Your Lordship. These are two separate incidents though. The incident of taking permission and the university refuting it was only specific to Aryavada National Law University. These were generic orders. These are general orders which are issued to the entire state of Mistara and Vivek, Your Lordships. May I proceed with the submission in the issue to Your Lordships?
No.
Much obliged, Your Lordships. Your Lordships, furthermore, if the council may draw the attention of the court to flag number 17 of the compendium in Ramesh vs. Union of India, it was stated that a motion picture or a documentary itself has a very strong audio-visual impact on the people viewing it. Which is to say that there are a large number of people watching the documentary, there are a large number of people watching a motion picture. Whatever content that it shows will have a very strong impact on the people who are watching it.
Can you compare this viewing of movie with this students' documentary scene within their campus or within their resort? Can you compare that?
Lordship, indeed not. It's not comparable. It is indeed not comparable. Your Lordships, the public screening in the universities what was the state of debate. If I may draw the attention of the court to paragraph number 4 of the proposition and paragraph number 3 of the proposition. After the documentary was released, there were certain heated debates that took place because of the release of the documentary, which further led to the escalated tension. And to prevent the same, the blocking orders were issued a blanket blocking order was issued to make sure that the same doesn't take place in the universities. As the council has mentioned that communal tensions might be very common in a country like this, but however the accountability for the same and the duty for the same is on the government to make sure that it doesn't happen. The government was doing exactly that. The government was only trying to perform their function. Was only trying to make sure there is no threat to national security and there is no threat to public order. And in furtherance of the same, they issued the blocking order, which were the least restrictive measures.
In spite of your barring order to this speaker and to the students, they got it. Okay. And from there only, what is their source? Student source, get this documentary. What was the source? Social media.
Indeed.
So social media was responsible for releasing. You have not prosecuted social media.
IT Act provides all that. It's still wrong. So
You have not prosecuted them. You prosecute simple for
that person. So any filmmaking now, any film which is derogatory or harming and all. So the government is trying to ban that film. But it's filmed, so there is a certificate taking that is unfair. So there is a question of taking other actions, preventive detention actions instead of taking action.
Indeed not, Your Lordship. Your Lordship, the council totally understands the concern. However, in the instant case, Your Lordship, the riots which have been talked about in the documentary, it's the 2002 riots. Within 2002 to now 2025, there would have been multiple sources on the same documentary. The government hasn't banned all of them. Nothing in the facts mentioned that everything of that sort was banned. Why just this documentary? Because it poses threat to the public order, because it poses threat to the national security, and as it has already been stated in the facts that the material which was used was undisclosed, unverified, and there are certain edited footages which could mislead the readers. And therefore, this particular documentary, only this material regarding the 2002 riots were blocked. Only this particular material, and therefore there has been no violation of the freedom of speech and expression. They can still hold discussions.
Where did you get that 2002 material? Okay.
Your Lordship is given in the facts of the case.
Where?
Paragraph 2 of the proposition, it says that 2002 Mistara riots.
So the act of the state government or concerned against whom allegations were of 2002.
No, Your Lordship, no.
BBC producer.
2002 is the riots.
2002 are the riots. That's exactly what council stated.
So BBC released it in 2024.
No, Your Lordship.
Is 2002. You say all the laws are India.
Read paragraph 2.
Indeed,
In
Your Lordship.
January 24, BBC released the two-part investigation document titled so and so, exploring alleged lapses in the state accountability during 2002. It's not that incidental.
Riots in 2002.
That's
Yeah,
it.
indeed, exactly what the council is saying, that the incident, the riot, which the documentary is about, not the documentary itself. The document was released in 2024 itself. The incident that the documentary talks about was 2002.
2002, yeah.
And what the council is saying is that from 2002 to now 2025, there would have been multiple sources talking about the same document. There are multiple sources talking about the same rights, not the documentary. The council would like to correct us that. There have been multiple sources, multiple media platforms, multiple documentaries. There's a possibility there might have been multiple documentary talking about the same Mistara riots. Why blocking issues?
Okay, here court would like to know regarding the 2002 Mahindra riots, whether any action was taken by the appropriate government then, any commission, committee, this and that, findings, court interference, anything has happened, whether court has given any direction like there should not be any shooting on this, no personal documentation, this and that, anything happened?
The facts remain silent about that, Your Lordships. The facts remain absolutely silent about what happened back then. They're only concerned about the documentary right now. They don't talk about what happened in 2012.
Of course, the facts is not there, but court would like to know whether the government has taken any action between.
That's it.
Because that it's very clearly says, acts and facts, no, it is akin to India.
Only law.
Indeed, Your Lordship, only the law.
Only law, not
Only the, okay, sorry.
I think not that because that means they have to go into the realm of imagination.
Sorry.
Furthermore, Your Lordship,
What's the your own argument now I think cuts at the root. When you say between 2002 and 2024, these 22 years, there is every possibility of the same incident being discussed, talked about. Then why after 22 years you suddenly get some pure psychosis and ban it?
indeed, Your Lordship, but the material that might have been used in the sources back then might not be the same that the material that might have been used in the sources back then might not be the same material that is used for this particular documentary.
And it has been there for all these years, people have talked about it, debated
Indeed,
it,
Your Lordship.
condemned, praised, whatever.
Indeed.
Why suddenly ban it now?
Because the particular documentary has been made using certain unverified, undisclosed, and there are certain edited footages used to make the documentary, which misleads the people about what might have actually taken place back then. Just may I continue with the submissions? Much obliged, Your Lordships. Your Lordships, the counsel for the petitioners have also stated that there is no harm, there is no harm to the diplomatic relationships. They have referred to the paragraph 12 of the proposition, saying that there were certain foreign governments which refrained from commenting or which refrained from making any comment, citing non-interference. However, Your Lordship, the same paragraph also states that there are certain international media watchdogs who have issued statements condemning the ban. There are multiple international platforms, and just like how Indian media has managed to influence the people of India, the same way international media can also influence the people of other countries. And that's why they have posed that there could be a possibility that it may cause harm to diplomatic relations. Furthermore, Your Lordships, as Your Lordship has wisely stated earlier,
Can you issue universal censorship?
indeed not, Your Lordship.
Then
Indeed, you are not, Your Lordship.
It is your concern inside this state.
It is.
Why you are worried about what happens in the other part of the country or what their comments are there?
That's because India also has a very strong relation and it requires international relations, Your Lordship. And
So you can't prevent the other countries or nations.
Indeed not, Your Lordship. That is not. That is
How you are preventing it?
Your Lordship, the blocking, in all practicality, the council agrees that the blocking orders issued within the country cannot prevent whatever happens outside the country. It's merely to ensure that there are no hostile dialogue exchange between the people from both the countries. That's only to ensure a very fundamental adherence to public order at large. Furthermore, Your Lordships, as Your Lordship has very wisely stated, that the right to dissent with the government, a right to not agree with whatever government does, is also a part of freedom of speech and expression, which is absolutely correct, Your Lordship. The council won't deny that. However, the same dissent, when it's combined with when it's also combined with international terror, or when it's combined with threats to public order or threats to national security, it goes beyond the ambit of just being dissent. It poses a threat to national security at that very bar. The moment it starts posing threat to national security is where it goes beyond being merely dissent. And therefore the same ground cannot be applicable in this case, Your Lordships. Your Lordships, if we are satisfied, the council seeks permission to proceed with the third submission. Your Lordships, the third issue deals with whether the procedural safeguards under section 69A were adhered to, or the actions of the Union of Memoria were arbitrary in nature. The council will be dealing with the same in three folds. The first being that the state has acted within their legislative capacity, Second being that whatever actions were taken by the state passed the test of reasonableness, and fourth being that it also passes the test of proportionality. Your Lordship, section 69A, if I may read out, it empowers the central government to issue blocking orders against any information that it is satisfied is necessary or expedient. There are two different thresholds in the present section, Your Lordship: necessary and expedient. Necessary is what has been upheld in Article 19, Clause 2. Expedient is when the government finds it is convenient for it to take a certain action to ensure there is no threat to public order or national security or friendly relations.
This is exactly what we are saying. You find it yourself convenient because there are allegations. We are asking where was your subjective satisfaction? What is the material you are
Your Lordship, the satisfaction in the instant case.
What is the satisfaction required under 69A?
In the 69A, there are certain grounds based on which a blocking order can be issued. Those grounds are threat to national security, public order, threat to friendly relations with foreign states, or preventing incitement of commission of any cognizable offence. Your Lordship, if the council would draw the attention of the court to flag number 4 of the compendium, in Madhyam Broadcasting Limited versus Union of India, they have defined national security, but also while looking into the components of national security, they have said there cannot be a straight line formula for national security. National security cannot have a very straight definition. However, they have stated there are certain components to national security. The components being socio-political stability, territorial integrity, economic stability, strength and ecological balance, culture cohesiveness, and external. Your Lordship, the very social stability in the instant case is threatened, and the same is substantiated by the facts itself. If the council will draw the attention of the court to paragraph number 4 of the proposition.
Section 69A, you are saying there are provisions. So if there is a violation, there should be some penalty.
Indeed.
Right? So the question from that time the bench is trying to understand is, was preventive detention the only remedy that you had, or did you have any alternate remedy? Why have you invoked the highest and not the others?
Preventive detention was for the fact that there were already prohibitory orders under section 144, despite which they have tried to do public screenings, and therefore they were preventively detained for a temporary period of time to ensure that whatever has already transpired in other states in terms of communal tensions, in terms of property damage, and whatever disturbances that took place there are not repeated in other places. Universities being the hotspot of debates in the current era, where there have been already multiple instances, the JNU incident itself, how the Lordship has pointed out, there have been multiple instances where discussions, mere debates in universities within the territorial area of the university itself.
There is no law, there is no provision other than preventive detention that could have applied. Is that what you are saying?
In the instant case, the state felt it was necessary to have preventive detention, therefore they have acted upon this.
Speaking of the documentary,
That's all.
by military force, you don't
Freeze the material, that's all.
enforce the ban.
Enforce the ban.
You don't have to take anyone into custody.
Indeed, Your Lordship, the council understands that. However, in the instant case, whatever grounds have been posed under section 69A, that is threat to national security, public order, they were immediate apprehension, there was imminent threat to those grounds, and therefore the government had to take extreme steps. However, it is also stated by the council already that the restrictive orders, that the blocking orders issued under Section 69 were the least restrictive measure that could have been posed in the instant case if the council would draw the attention of the court to flag number 31 of the compendium, a commentary by Honorable Justice A.K. Sikri, proportionality as a tool for advancing rule of law. In the same commentary, Honorable Justice has also stated that the test of necessity. No, Your Lordship. There's a commentary by Justice A.K. Sikri, Honorable Justice A.K. Sikri, proportionality as a tool for advancing rule of law 2019. In the same commentary, Honorable Justice has said that the test to make sure that the restriction that was posed was least restrictive in nature. The test is whether the respective measures, the test is not that whether the measures achieve the objective to the same extent. It is whether it is achievable with in a real and substantial manner. Any alternative that was possible under Section 69 could have been disclaimers or advisory, and advisory was already issued by the Press Council of India. Any disclaimers would not have hindered the threat in the same substantiality that the blocking orders did, and therefore it became imminent. It became very important to issue blocking orders.
So I think that's not much of a difficulty about blocking order. Blocking order you issue and enforce, but why take a person into custody?
Your Lordship,
that is where the thrust comes.
Your Lordship, it was only done to take a preventive step to make sure that the same disturbances which have already occurred in other states don't repeat here. And that was done temporarily. And Your Lordship, if the council may draw the attention of the court to paragraph number 14 of the proposition, they have also stated that there were certain financial records that revealed, which means they have already looked into it, and the financial records have revealed that the certain activist groups supporting the scheme was
not the students group, it doesn't say students group.
Indeed, Your Lordship.
It is a general, they are outside.
Indeed, Your
They are
Lordship.
taking drastic action against the students.
Your Lordship, the actions that were taken against student in the instant case was only to prevent whatever has happened in
Paragraph 14.
Yes, indeed, Your Lordship.
That has nothing to do with this.
Indeed, Your Lordship. But to answer your question, that the preventive detention orders are again
The more you press your argument, you are only exposing your inability to govern. When you say that
What appears to be BBC says.
and if you have to take a student into custody to enforce a ban, which means you can't enforce a ban if he is outside. Then doubts have to arise about your competence to govern.
Your Lordship, the council understands the concern, the council absolutely acknowledges the concerns of the Honourable Bench. However, Your Lordships, as the council has already stated, that the preventive...
So the court can come to the conclusion that the council agrees the government has committed a blunder.
The government
And it is for
Indeed not, Your Lordship. Indeed not, Your Lordship.
Then, see, if there is any breach of Section 69 punishment is vested, send it to jail for 7 days. Done?
Indeed.
If there is breach of 144, take action according to CRPC.
Indeed, Your Lordship. Indeed.
How you draft preventive detention that protects you under the Constitution? Simple as that.
Your Lordship, if I may draw the attention of the court to
And all the remedies are like that.
Indeed, Your Lordship, the council agrees with
This was not lawless.
Drastic.
Indeed. Your Lordship.
So then court can read more and more regarding the intention of the government, right?
Indeed, Your Lordship. Your Lordship, may the council deal with the further submissions.
Yes.
Your Lordship, the next submission that the council will be dealing with is whether the impugned action are arbitrary in nature or not. Your Lordship, in E.P. Rauka versus State of Tamil Nadu, the Supreme Court has said that arbitrariness is antithesis to equality.
When
1974.
1974, lot of water has flown on the bridge face.
Indeed, Your Lordship, in a 2002 judgment of the Supreme Court,
The water has flowed in the same direction.
With little difference.
The broad proposition remains.
Lordship, the last ground that the council will be
Yes, please.
Lordship, the last ground that the council will be dealing with is the reasonableness of the impugned actions. Lordship, in TNA 5 versus State of Kerala, a 2002 Supreme Court judgment, it was stated that when equality is hindered or when equality is curtailed, the right to equality under Article 14 is curtailed, it has to be ensured that it's based on reasonable classification based on intelligible differentiation. Lordship, in the instant case, whatever the classification has been done, it's not between two groups or two sections of people, it's between two mediums of dissemination of content. Lordship, blocking orders under section 69A are stricter than whatever measures will be taken in any other case of blocking dissemination through any other medium, the intelligible differentiation for which was held in Shreya Singhal versus Union of India, if the council may draw the attention of the court to flag number 26 of the compendium. Lordship, in Shreya Singhal versus Union of India, it was said that the medium of internet rumors have a serious potential of creating a serious social disorder because the information via internet can be spread to trillions of people without any check, which is not possible in case of any other medium. And therefore, a more stringent rule has been made applicable via section 69A of the IPR. If your lordships are satisfied with the submission, the council now seeks permission to proceed with the prayer. Much obliged, your lordships. Therefore, in the light of the facts stated, issues raised in arguments advanced and authority cited, it is humbly pleaded before the Honorable Court to dismiss the petition, to uphold that the preventive detention of the students and the activists were lawful, to uphold that the blocking orders issued were not in contravention of Article 19, Clause 2, to declare and adjudge that the procedural safeguards of Section 69A are reasonable, adequate, constitutional, and were adhered to declare that the state of Bulgaria has acted within the constitutional framework while imposing the ban on the documentary, and or to pass any such order in favor of the respondent as it may deem fit in interest of justice, equity, and good conscience. And for this act of kindness, the counsel for the respondent shall remain guilty. It was an honor arguing before the honorable bench.
You want any reply?
I won't take up too much.
No, you want it? Want it? Yeah. You will not.
And not reply. If you raise any new reply, new thing, then again they are not right.
Honorable bench. Honorable bench, one thing that hasn't still been justified on their side is which law did they use to preventively detain? The whole premise of Article 21 is procedure established by law. Which procedure established by law does the respondent use? Their entire memorial and their oral argument has not once mentioned which law they have invoked. And honorable bench, their entire premise rests on Article 22 Clause 5, which talks about procedural safeguards. And honorable bench, the moot proposition hasn't once said that they have stated ground. The moot proposition actually shows that they didn't show what grounds they were detained under, let alone what law they were detained under. Honorable bench, the second point, they have constantly stated that there is a threat to national security. Not once have they justified how the threat is occurring. How is the documentary going to cause a breach of national security? Just saying that it does is not going to suffice, honorable bench. They have not gone into the ingredients of it. Moreover, honorable bench, they have constantly mentioned one particular word, that the documentary was based on unverifiable sources and that the press council had said it. Honorable bench, that is not the case. Paragraph 3 says that when the state was defending itself, it made a claim that it was unverified. The press council only said that the sources were undisclosed. Just because the source is undisclosed doesn't mean it's unverifiable. Moreover, honorable bench, one last point. They stated that the blocking order under 69A is temporary. The blocking order happened in January of 2022. This writ petition was filed in 2025. 3 years is not temporary at all, honorable bench. And that is all for our humble submission. Thank you for your time.
Yes.
Your Lordship, the Council has already dealt with the ingredients of national security. Why we refer to the case of Madhyamam Broadcasting Limited versus Union of India, where they said that national security includes certain grounds, certain components, which are socio-political stability, which have been threatened in the instant case, given the communal tensions, given the the property damages, and given the fact that there have been sporadic protests throughout multiple cities. Furthermore, Your Lordships,
The point was under what law? What we have to replace under what law? Which law was violated?
You took action
You
under
took
law.
action under which law? Isn't it right?
Your Lordship, there were 4 rebuttals that I am getting. Your
Let's
Lordship,
rebut that.
Yeah, because that's the most
That's
important.
only important.
indeed, Your Lordships.
Okay, proceed, proceed.
Thanks, Lordships. Furthermore, they have stated that the council for the respondent has said that the press council has said that the sources were unverified. The council is aware that what the press council stated was that the sources are undisclosed and there are certain edited footages used to make the document. However, it was the claim of the Prime Minister office that the material which was used for making the documentary was unverifiable in nature. But the advisory which was issued by the Press Council of India, the advisory which was issued by the Press Council of Memorial was has stated concerns related to ethics of journalism, which means that they were not in favor of whatever material was used by the documentary, and therefore an advisory was issued by them. Furthermore, Your Lordships, preventive detention was one of the section prohibitory orders under section 144. In consequence of which they have taken action to preventively detain the students. It was in consequence of the fact that there were certain prohibitory orders under section 144 which were not adhered to, and therefore they had to take steps to preventively detain the students.
The action was taken as per your piece.
Indeed, Your Lordship, in furtherance of not the IT Act, Your Lordship, indeed not.
You must face
Your Lordship,
some law, some state law.
Your Lordship, in Schedule 7, list 2 of Schedule 7, entry 1, it allows the state to preventively detain.
So that's law. There is no trouble about
Law being there, we have no problem.
but you must say under which law you took action.
That's the only answer the council has, Your Lordship. That's all. Or the normal argument.
I would now like to introduce our esteemed judges. The first judge for today's round is Justice S.R. Banukumar. He is a distinguished jurist and former Chief Justice of the Kerala High Court. After earning his law degree from RL Law College, Belgaum, and University Law College, Dhawar, he built a remarkable legal career specializing in civil, criminal, and constitutional law. He served as Karnataka State Public Prosecutor from 1990 to 1997 before his elevation to Karnataka High Court, where he delivered.
Sorry for interrupting the chair. I think you are introducing us all at the valedictory functions.
Yes.
That's what. So I think we'll skip this because we are already more than an hour behind time.
So, court adjourns the entire.
Judgment reserved.
The participant.
No, you can keep your right.
The participant may now leave to the Rainer Auditorium for valid disposition.